I'm signing on to his new case.
Oh, it's a new case.
He did, Judge.
Mr. Palacio, you're now charged with a new case. You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine.
Notice how quickly the judge establishes a probable cause process. This isn't just formality. It's the foundation of whether the case even moves forward. Without it, the charges can collapse before they begin.
We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
On February 5th, 2025, the officer was dispatched to a stranded vehicle at the 700 block of North San Houston Parkway, and the officer observed a car parked on the shoulder and a driver asleep at the wheel with the engine running and the car in park. The officer knocked on the window to wake up the driver.
Did you catch that? The defendant kept shifting between park and drive before stepping out. That hesitation might seem small, but in a courtroom, it screams of impaired judgment, and the judge will not ignore it.
Who woke up and refused to comply with the officer's command and drove the car 6 feet forward. The officer then requested the defendant exit the vehicle. The defendant put the vehicle in park, then drive multiple times before finally exiting the vehicle. The defendant was detained upon exiting the vehicle, and the officer relocated to a gas station where the defendant was observed to be dazed and confused and did not realize he had been asleep at the wheel. The defendant was also unable to communicate where he had been or where he was going. The defendant was asked to perform standing field sobriety tests, GN 6 out of 6, walk and turn 5 out of 8, one leg stand, 1 out of 4. The defendant was read to DIC and declined to provide a sample. The blood search warrant was signed and executed.
I'm going to find that there's probable cause to go forward with the case. Can you look to see if he has any prior DWIs?
And there it is, the bond revocation. Judges don't play around when defendants repeat mistakes while already on bond. Audience, what do you think? Should enrolling in treatment programs soften the consequences, or is bond revocation the only fair response?
Does he have a valid Texas driver license?
He does have a valid driver's license, Judge, and we did file plea last hearing.
And then I see he has a dismissed DWI out of Fort Bend and no other DWI.
There's no probable cause in that case.
I'm now ordering you. Well, the first thing I'm going to do is I ordered you on your first case not to consume alcohol or illegal drugs. You've now picked up a DWI. Guess what happens now? I'm revoking your bond.
Judge, I would like to address that. So he does realize that this is a problem at this point, and he has enrolled himself in IOP and does have a meeting this afternoon to do intake for IOP, and I do have that email.
I can't show him preferential treatment on any case here. I ordered not to do something. He did it. A new case. You're staying with me. And I'm going to tell you now. If I find that you consume alcohol again, I will put you in a rehab facility myself, in the jail. And if you respond well to treatment, it's a minimum of 9 months. Do you understand?
Sure.
I'm now placing a restriction that you're not to drive any vehicle that doesn't have a guardian interlock on it. You're not to consume alcohol, illegal drugs, and Casey, I'm now going to probably give him a curfew. In the BMV, was he out in the middle of the night? Alex?
Yes, Your Honor.
I think it was after a bar closed. He was just sleeping in the owner's vehicle.
There's one consistent problem, and there's one thing that centers around every single problem that you have. What is that one problem? You and alcohol do not mix. And I don't know what we need to do to get you to realize that. But I don't know. I hope that this is it. If it's not, it's going to be rather lengthy. Maybe that's it. Is it prison? I don't know. But all of the issues center around one thing. And I hope that you now realize this and do what you need to do. Because if you can't take care of it yourself, I will do it for you. And I promise you're not going to like the way that I do it. Do you understand?
Yes, sir.
Okay. It goes with you. And then when he comes out, or when he does bond out, he's going to have to come back for bond conditions and then carry it.
Bond conditions today on that non-revoked case, so they'll be active.
Okay. No, just what time was
The only time the officer gave was when they got the blood samples, and that was at 7 a.m. So sometime prior to 7 a.m. But he doesn't say how, how long before the blood was actually drawn.
What do you think about a curfew?
Judge, if I may, he is active military, so he is still reporting to that. They're also looking to get him help. He has enrolled himself in IOP, so he does have a job.
I won't curfew, but if he picks up a new case,
I understand. We had a big conversation, and he's the one that took it upon himself to realize that this was a problem, and he told me that he was going to use his VA benefits to look into the IOP at this point. So he did send me that email that he is confirmed to get enrollment.
This escalated fast. From a DWI to a motor charge tied to a drug deal gone wrong. This is where you realize how one bad decision can snowball into a life-changing disaster.
IOP.
okay, so on the DWI, just pick whatever date you have. When he does bond out, he'll get a 7-day setting. Whenever day that you get, just let Ramona know or Victoria, and then we'll give you that day. Feel free to email them, and then we can carry it. Okay? All right. I was going to set it at 5,001. That's what I normally do. Okay. Yes, ma'am. Okay. Thanks. Sorry, Mr.
I just filed a revoke and raise. He picked up a murder charge.
Wow. How old is this kid? What happened?
17.
17. He picked up a murder case. What happened?
From my understanding, it was a weed deal gone wrong.
Oh, I read about this. Right. Really? I'm just so disappointed, Mr. Jones. I can't tell you how disappointed I am. You've got but one life to live. Just one. You don't get multiple chances, man. You're not a cat. I'm bringing you out here because we're talking about you, and it's only fair that you hear what's going on. Because you've now picked up the murder case upstairs, the state has asked me your bonds are now set on both of your...
By this point, we've already seen bond revocations, DWI warnings, and even a murder charge pop up. But here's the bigger question. Are these courtroom restrictions enough to actually stop repeat offenders, or are they just temporary fixes?
Cases on your assault and your criminal mischief, they're both set at 5,002. They did not give you a PR bond on those cases, and the state has asked me to revoke and raise those cases because you are a danger to our public. You've not made bond on those cases, so I'm going to deny their request to revoke and raise your bonds. But I'm going to tell you now that I don't know if you're going to get out because your bond is set at $250,000 upstairs. But if you do, I don't want you to go anywhere. I want you absolute home confinement, 24 hours a day, 7 days a week. Do you understand? And you will have a GPS monitor, no drugs, no alcohol, no weapons, anything else?
No, Judge. Nothing.
And I guess just keep me in the loop what happens upstairs, if they do anything with the bonds, just keep me in the loop so we can kind of stay close. The other thing is that thing's going to take a while to play out. And I'm not going to hold it for 2 years for it to play out upstairs. So let's try to find some kind of resolution so we can, they can worry about it upstairs and then we can just, okay? So I'll obviously give you a sufficient time. Is discovery complete? Because these cases are from November. They're old.
We're still waiting on body cam, dash.
That's not good. Wait a second.
November.
I guess they may have been 2Bs though. Let me see if that's right. Because if there were 2Bs, then
Actually, Judge, it looks like we have all of the body cam. It wasn't complete. We have the 911 calls.
Oh, so you've got this
Pay
discovery
close
complete.
attention here. The defense lawyer is hesitant to plead guilty to assault because of the new murder charge. Why? Because a guilty plea now could be used against the defendant later during sentencing. Smart legal strategy are delaying the inevitable.
Discovery is complete.
It looks like it, yes, Judge.
Have you given offers on both of the cases?
I have not, Judge, but I'll take a look on his,
There was all, but.
there was,
Counted out the options.
we had offered a 13-month deferred. I revoked it, obviously, with the new law violation.
Sure.
So I'm probably just gonna check his credit and put a jail time offer.
Okay. So I'll give you some time. Take a look. Speak with Mr. Jones what he wants to do. The cases are kind of old, so when we come back in the next time, you must accept the offer from the state. Otherwise, I'm going to set your cases for trial here. You understand? Okay, man.
But in all honesty, I can remember and know right now that seeing the U.S. Of every case, I would be reluctant to be indicted to an assault case because that is a punishment. He's in no trouble. Make for us at the trial. Just not going to just live along this case.
I'll speak to the felony, I mean, the murder was just filed a couple of days ago, so I'll speak to the felony, see what the CW wants on the assault.
So let's set it a week
and
out.
look at it.
Talk to felony, see what they want. In a week, we can set it. Yeah? Okay. All right. Good luck. Does he have any prior DWIs? Do you know if he has any prior DWIs? Okay.
I'm not gonna wait. I'll run it for SSC if you'd like.
Please, you need to understand that DWIs are big business in Texas, you know. Watch the news. Every single day someone dies from a DWI. That's why they have made the penalty so darn severe. Third DWI, you're looking at prison, up to minimum of 2 years in prison, a maximum of 10 years in prison. What you're doing is pleading guilty to this offense. The DWI is going to go on your record. It will be there for the rest of your life. And what you need to understand is that whenever you get pulled over now in the future, first thing an officer does is they're going to look at your record. If they see that you have a prior DWI, a prior PCS, and they come up to you and they smell alcohol, they smell any kind of funky smell, what do you think they're going to do?
The car.
She's take you to car.
Take me to jail.
Probably so. You know, from now on, you're facing a minimum of 30 days in jail. Any new cases that you pick up. No more verbal slaps on the wrist. Do you understand?
Yes, sir. Yeah.
If I were you, even if you have had a sip of alcohol, I wouldn't get into a car. It's a humongous risk that you're taking. You understand? What you have worked out is 180 days in jail to be probated for 1 year. As part of the conditions for you to complete this probation successfully, you must do a DWI education class, 2 victim impact panels. You must also do what's called a TRAS. This is an evaluation to see what conditions you may need. They assess other conditions like, supportive outpatient treatment, intensive outpatient treatment. You must also fulfill those as well. No drugs, no alcohol, guardian interlock, no breath test refusal. What that means is that if you're pulled over in a car, an officer asks you to submit a breath test, you must do it while you're on this probation. If you don't do it, you're in violation. If you violate this, I'm going to issue a warrant for your arrest. I'm going to put you in jail. I'm going to bring you back out. We're going to talk if you violated your probation. If you do, you're looking at 180 days in jail. Do you understand?
This would also be a little 30 years.
Notice how the judge keeps hammering the consequences. Probation, fines, interlock devices, and jail time. It feels like a scare tactic. Do you think fear really helps people turn their lives around? Or is long-term treatment a better solution? Drop your thoughts below.